Number 36, matter of 8th Judicial District asbestos litigation. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is John Lipsitz, and I appear today for the estate of Donald Terwilliger. Chief Judge, I'd like to reserve 3 minutes for rebuttal, if that's all right.
Did you say 3, sir?
3, please.
You may.
We're here before this Court on a motion by Respondent Honeywell for summary judgment. Donald Terwilliger developed a fatal lung cancer as a result of breathing in toxic coke oven emissions, dust and fumes from coke ovens.
Let me ask you this, which is, this is a failure to warn claim, right?
Correct.
And so we have to decide whether this whole line of cases, failure to warn, strict product liability, applies in this situation. What's the test that you would use to figure that out?
Well, Your Honor, I think you'd have to go and look at a long line of cases beginning with this Court's decision in 1852 in Thomas versus Winchester, where the Court said you have to look to the nature of the business and the extent to which that business involves the sale of things that can cause harm, serious physical harm.
What if it involves two things, a product and a service? Then what's the test? Do we do a weighing, or is it? I guess I see our jurisprudence as looking more to the policies, the public policy involved in strict product liability. So I'm not sure exactly how you would frame that.
Your Honor, in this Court's decision in 1977 in the Malau case, the Court discussed the sales services continuum, but it did say, with respect to cases involving personal injury, that you do have to look to the public policies underlying the application of product liability for a manufacturer or seller's failure either to warn or because they sold a product that had a manufacturing defect or a design defect.
So here you have the seller is providing something. We won't give it a label right now. And the purchaser is a very sophisticated, large producer of steel, okay? So in terms of our policies about who's better able to, and as I understand the record, Bethlehem was very involved in actually designing all of this. So how do our policies about who's in a better position to determine and create a safe thing?
Two things, Your Honor, at least two things. One is that I beg to differ with you about the role played by Bethlehem Steel. Yes, it was a big manufacturer of steel, but every single element of the coke ovens that were sold to Bethlehem Steel were designed, marketed, advertised, and certain component parts actually manufactured on Honeywell's, or rather Wilput Coke Oven's own site, and it was all sold. And there was a knowledge on the part of, and we're here on a motion for summary judgment, so clearly. So
what did Honeywell's engineers and all those people who approved plans and disapproved plans, what did they do?
All Bethlehem Steel's people did was say, we need so many coke ovens to meet our production needs. There's nothing in this record which indicates that Bethlehem Steel had a hand in developing the automatic closing doors of the ovens, the heating elements of the ovens, the pusher mechanism.
Once it's purchased, is there anyone else who can build it?
The only company that you could only get a coke oven by going to two really coke oven sellers in the United States. There was Copper's Company and there was Wilput Coke Oven Division. So you really had no choice. I mean, that was the market. They advertised, they competed with one another, and the Wilput division, Coke Oven Division, sold lots of coke ovens to Bethlehem Steel.
I'm saying you couldn't buy it from one and then go to someone else for them to actually put this together so that it functions in the way?
I don't think there's any evidence that
Anticipate.
ever happened. I mean, all the technology was on the side of the Wilput Coke Oven division. None of the technology for,
Would they sell it without then putting it all together for use?
no, it was actually proprietary. In fact, in the contracts, there's some terms that say, look, this is our technology, this is our thing, this is what we sell, and we don't want anybody infringing on our proprietary information.
Well, they
even
actually
went-
registered with the Patent and Trademark Office. But the discussion so far is focusing on the differences between Bethlehem and Honeywell and so on. My concern is, what about the third party here, who's the decedent and the plaintiff, and what are the duties to that person? And I guess I don't want that to get lost in this discussion, because this other discussion is really about an allocation, it seems to me, between the defendants, and less about whether this defendant had a duty to warn this plaintiff.
Can we get, Your Honor, that brings us back, I think, to a case like Sprung, which was decided in 2003. And in Sprung, you had two sophisticated parties. You had the seller of a retractable sheet metal device
Right,
used
the
at
floor.
a floor, and it was sold to, I think, General Motors, which was a sophisticated party. And the court said, well, even though there was some customized nature of this article, which was sold by a company in the business of selling sheet metal, we're not going to decide on this motion for summary judgment that you can't bring a products liability case against.
Yes, but in Sprung, the customer had nothing to do with retractable floors. It was a turbine manufacturer, so it may have been a sophisticated party, but not in the subject of the injury-producing thing.
Your Honor, if you search the record, you will not find any indication that, other than bald assertions, but you'll find no evidence that Bethlehem Steel had any hand in designing any of the constituent parts of the coke oven.
Can we go back to the duty to warn for a second, Ms. Lipsitz? How long did the deceased work there?
The deceased worked there beginning in 1954, but in 1966 he was assigned to work as a laborer in the coke oven division.
And how long did he work in the coke ovens?
Through the 90s.
Through the 90s. Was there ever a warning given to him that these hazardous emissions could lead to physical damages or cancer?
Yes, in the late
When was it?
70s, pursuant to a regulatory regime imposed by OSHA, placards were put on the tops of the oven saying cancer hazard.
I
And
see.
that could
Were
have
there
been done.
respirators ever given out?
Right, yes.
Were there respirators?
At a certain point, respirators were mandatory.
I see. So it's about 10, 12 years.
Yes, around and that.
They worked in the ovens without any warning.
That's correct.
Your fourth cause of action says strict liability on its face, but the second one reads to me like just a straight negligence claim. Am I reading that correctly or no?
Your Honor, you're reading it correctly, but the way that the complaint was drafted, the second cause of action and the fourth cause of action are both really negligence-based product liability claims for failure to warn. It was drafted so as to make sure there was no question about it, so the word strict products liability is used in the fourth. But functionally speaking, in terms of the policies underlying the imposition of a duty to warn, they're the same.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. I'm Victoria Graffione, along with my colleague Svetlana Ivy. We are representing Honeywell, which was the predecessor to Wilput that designed and built this coke oven battery in Lackawanna.
So let me ask this, Counselor. Is there a difference between a coke oven and a coke oven battery for the purposes of this case? Does it make a difference?
I think for this case, it doesn't, Your Honor.
Why is that?
The coke oven itself is not a functional object.
Well, the idea of a coke oven
is
is
brick
all-
walls that were
Excuse me.
integral.
The idea of a coke oven is almost 600-700 years old. They forged steel out of coke ovens in the 1400s. They were doing that. So it's a machine that converts a product into a hardened steel type product. So the battery itself is a combination of those machines. I spent my life driving by Lackawanna Steel. So that to me seems a difference in terms of the building itself, and one seems to be either a process, you could call it, or a machine for converting one thing into another, and the second thing seems to be a building that contains all of those things.
If you look at page 9, the illustration in our original brief, the coke ovens don't contain any of the machinery. The machinery, which is the piping and the heating units, are in the battery. There, the lower level is the underjet, and then the piping is on the external to the actual coke ovens. The coke oven itself, and there's 76 of them, has no machinery in it at all. But I don't think it's the size or whether this battery or coke oven is a machine is the issue. I think that this court should uphold the dichotomy that for 40 years it has applied as to whether we're dealing with a sale or we're dealing with a service.
I see.
Well, what
Here-
do you
here
do,
we
what do you
don't
do,
have-
what do you do when the commercial transaction is to purchase a, let's just say a machine for purposes of this moment, for this question, that can only be supplied by one particular manufacturer, can only be installed by one particular manufacturer?
Well, it's really no different than any other kind of specialized construction project.
Yeah, but
What
at
you
some
had-
point, isn't someone responsible, if in fact there has been a breach of a duty to warn, who carries that duty?
Well, in order to have a failure to warn is
Yes.
just one of the 3 grounds for product liability. You still need to have a manufactured product. And our basic contention is that Wilput was not a manufacturer. They did not produce anything at a Wilput factory. This was
Well, because it couldn't, but
this facility was completely built on site.
No, I understand, but because it cannot be built at a factory and then brought over. You have to build it on site. It is unique, and so these are case-by-case determinations.
Well, I don't know if it's unique. We have many commercial
But
and
isn't the
industrial.
analogy in the case laws things like elevators, gas turbines? Those are products that may be built on site as part of a larger complex.
Well, in the GE turbine cases, in the elevator case, those were actually built at a manufacturing
Well, some
facility
parts were, and some parts
delivered.
weren't, right?
But I think the real issue here is that the court has applied the test of whether it's a predominantly service contract. And certainly, when you have these kinds of industrial facilities, the designers and builders acknowledge that the plaintiff may have a remedy under
But under
professional
your rule,
malpractice.
under your rule, who, if anyone, would have had a duty to alert the people who work there of the carcinogens and the dangers?
It would have been the employer. It would have been Bethlehem Steel. Also, they could have had a negligence cause of action
If
here.
I may, assuming for the moment, and I'm not saying this is where it's going to end up, obviously, that it is a product. And if it is a product, and how do you then sort of fashion a rule that doesn't allow this to be sort of applied in a broader sense to like general contractors who may be building a home or something of that nature?
I don't think there should be a different rule. I think the rule should be the construction of a building or a commercial structure is not subject to product liability where the designer or the builder is performing under the terms.
So your rule is dependent then on this product being deemed a building or a structure?
Yes. If you look at page,
So are you,
if you look at the title of the cover of the advertising material that the plaintiff relies upon, it's in the record at 445, we'll put immediately on the cover page says designer and builder of coal, whatever.
so how do you deal with our decision in Inman v. Binghamton Housing Authority, in which we approvingly quote the Pennsylvania Supreme Court for the proposition that the principle inherent in the McPherson v. Buick Motor Company case and those that have followed it cannot be made to depend upon the merely technical distinction between a chattel and a structure built upon the land.
If I could mention first, Inman is 1957.
Yes, it is.
And so it's decades before Codling. And in Codling was where the court first applied strict liability. So Inman they hadn't even promulgated strict liability yet here at the Court of Appeals. So I think Inman is not really relevant to the extent that it didn't contemplate strict liability. I think you have to look at the fact that, as you see in Millau, as you see in Sprung, as this court more recently indicated in Dummett, there's very distinct policy considerations between a manufacturer who launches a product in the stream of commerce and architects, engineering firms, and builders who construct buildings.
Right, so I understand your distinction. It's a fair distinction to draw. The problem with it is what you're asking us to say is that coke ovens, when combined together, constitute real property. That's the effect of your ruling. That's the effect of the argument that you're making. And that argument itself seems to be undermined by the real property law, where in the real property law, we take things like, we classify boilers, heaters, elevators, plumbing, a variety of objects that are all considered part of real property, yet nonetheless, under products liability law, they also constitute a definition of product. And so if I understand your argument correctly, then whenever property can be considered subsumed within real property, a product can be subsumed within real property, it's no longer a product, it becomes part of real property and therefore subject to that sales service distinction.
I don't think the Lackawanna case necessarily directs the result here. We're not saying that it becomes real property. Mm-hmm. We're saying that this was the performance of design and construction services to build a building.
I understood your ordinary negligence argument to essentially be that this was designed that way and covered that way, and it could be considered perhaps an action for professional negligence in some form by an architect or someone else. And that, to me, would constitute a building. That's why I asked the question.
Well, I think you also have to look at the ramifications. I think that it's a very slippery slope for this court to begin to say certain buildings constitute a machine or a product and certain buildings don't. So if you're an engineering firm and you're designing a water treatment or a wastewater plant, I mean, those are single function facilities that are built on site. Does that engineering firm say, we can't do this business anymore? We're going to be subjected?
I think you make a good point. But the components themselves that make up that plant may in and of themselves constitute a product. And that's what we're talking about here. We're not talking about the battery. We're talking about the oven. And there seems to be a clear distinction and a logical one for us to look at.
I completely agree with you if the plaintiff had designated any defective component. Mm-hmm. Because then you're clearly within your case law.
The way I understand their argument is
for defective component.
The way I understand their argument is the emissions from the component are the source of the problem.
But they still,
and it's a failure to warn about that. It's not a defective product design. It's not a defective design claim, as I understood it.
No, but even failure to warn requires, first of all, that you have a manufacturer, and we're claiming Willput is an engineering, a construction oversight company. But secondly, you still need to identify a defective product component.
So if they
and
had
they
said,
did
for
not
example,
do that.
if they had said the door was defective because it allowed release, you'd be satisfied?
That would have been perfectly acceptable. Yes. And that's what the case law of this court stands for. And I think if you look at the best example of this dichotomy and how it works are the trustees of Columbia University case. In the Mitchell case, they said, yes, you have alleged a defective product, that the panels on the building were defectively manufactured. But when the same, I think it's the same building, when the Siegel case came up, they said there's no allegation of a defective component. Therefore, it falls in the service category. And I think that, this is a clear rule. This kind of bright line rule is much easier for the courts to apply than a very ephemeral rule about whether or not it's a process. Is it a single-use building? Is it a machine? Is it not a machine? It puts the courts at a real disadvantage. And I direct your attention to the amicus brief because I think, and it was submitted by various interests in the construction industry, including a trade union, and it does create a great deal of difficulty for them. It certainly undermines what they expect they're getting into when they agree to provide these services. And the policy is so distinct. I'm sorry, my red light is on.
Thank you, counsel. Counsel, what are you arguing are the defective components?
Your Honor, if you go to page 446 of the record, you'll see a description in a paragraph written by Wilput in its advertising brochure describing the coke oven. And it has numerous constituent parts, including doors, heating elements that are contained within it, a pusher mechanism. The pusher mechanism, by the way, it was actually manufactured on-site at Wilput's offices.
But why shouldn't you have to identify the part or parts that are causing the injury?
That's a good question because I think our complaint is so clear. If you look at the second and fourth causes of action, we're not complaining about shoddy workmanship. We're not complaining that they didn't build the bricks in a way that a professional brick builder would build them. We're complaining about the fact that they knew that if you operate a coke oven, which is a unit that is used to subject coal to very high heat and an oxygen-deprived atmosphere with mechanical components that seal the doors and heat the inside, you're going to emit cancer-causing fumes and dusts called coke oven.
So in other words, it wasn't safe when used as designed.
When used as intended, it caused death. That's the problem.
I'm quoting from count 2. Did not take reasonable precautions in the design and manufacture.
That's correct.
So why not specify the element? Why shouldn't it be a rule that you specify the elements of the design that cause the injury?
We have specified, Your Honor, as humanly close as humanly possible. And again, we're on a motion for summary judgment. What we're complaining about is the functioning coke oven. The coke oven is a product. It's sold in 76 of them at one time for a battery to Bethlehem Steel. If you work on top of if you operate these coke ovens and you're not properly warned and you don't have the proper respiratory equipment, you're going to breathe in fumes and dust that this company, which was the designer and did everything about it, had all the proprietary equipment, had trademarks and patents, they knew they were in the best position to warn. Yes, Bethlehem Steel was a steel-making company, but Bethlehem Steel couldn't build coke ovens or buy coke ovens. They had to go to an outside vendor.
Your case is not that they could have built it in a way that's safe. This industry is inherently dangerous, like the cigarettes, right? The cigarettes, you want the warning on the package so people know that if they indeed go down this road, this may result in cancer or some other disease, but there's not a way, right, to make that cigarette safe.
The only way to safely operate a coke oven before the OSHA started a very sort of comprehensive regulatory regime was if you were informed that the dust and fumes were carcinogenic and you must use adequate respiratory protection. They never did that.
To reduce the danger, but the point is that you're in an environment that is fused with carcinogens.
Yes, but you could have protected yourself. He could have protected himself.
But that's my point. Your case is not anything other than they should have told someone so that they could take those precautions.
Correct.
As opposed to you have another way that you could have built it that would not have put carcinogens into the air.
It's not a design defect. It's not a manufacturing defect. We're not saying that they used poor workmanship to build the walls. They knew what they were doing and they didn't warn.
Thank you, counsel.
Thank you. Thank you, Your Honor.